Mira Real Estate LLC versus Nidal Zier. This is a property located on Millard Street in Three Rivers. Attorney Sumita Nagpal is here on behalf of the plaintiffs. The plaintiff, Mr. and Mrs. Patel, are also present. Apparently they own the Real Estate LLC. Mr. Zier is not. So let me see if he is outside here. This is a land contract forfeiture action for this property. I believe is a marijuana dispensary, a Joyology. It does appear, at least to me, Ms. Nagpal, that more than 50% of the purchase price has been paid. Am I correct?
That is correct, Your Honor.
Are they still in possession of the premises?
They are in possession. They are conducting business.
What is the current arrearage?
Rashi, do you have the current arrearage? The amount owing as of now?
I can look it up.
As of the date of filing this complaint, Your Honor, it was $153,273.09, but that is...
Yeah, I have that figure.
Yeah. And we've also amended the contract twice, where the parties agreed that if there was a default in the payment, the land contract vendee would be responsible for $300 per month. Late fees and reasonable attorney fees. And I think Ms. Patel is trying to...
This courtroom case isn't just about debt. It's about survival, strategy, and a business on the edge of collapse. Imagine juggling foreclosure on your real estate, fighting to keep a dispensary afloat, and battling eviction all at the same time. That's exactly what's unfolding here. The respondent is accused of dodging financial obligations while pleading for more time. The judge, however, is laser-focused on accountability. What's fascinating is the clash between financial desperation and legal procedure. One side demands structure, the other begs for leniency. And hidden beneath it all, a looming installment plan that could make or break this man's future. Stay tuned, because every statement in this hearing is loaded with consequences.
Yeah.
Has anyone had any contact with Mr. Zier or anyone who's operating the business?
Your Honor, I have had contact with Mr. Zier's potential attorney. He hasn't filed an appearance. That's my understanding. However, they are not sure what they want to do here, whether they want to ride out the 6 months redemption period or whether they want to become current with the land contract payments. They are not sure, but they decided not to attend the hearing today.
All right, and as you're right, since there's more than 50% of the purchase price, the redemption period is 180 days. I don't have an order in here, so you're going to have to send me one. At the time of filing, make sure I don't have a notice hidden in here. I don't believe so.
Yeah, I can send the order today.
All right. As of July 1, the arrearage is $150.
Right here, the case takes a dramatic turn. We're not just talking about unpaid bills anymore. The respondent admits he's battling eviction while trying to keep a dispensary afloat. Think about that for a second. Running a business requires stability, yet his personal finances are crumbling around him. This is where credibility matters. Judges don't just care about excuses, they want to see action. By revealing his struggles, he hopes to gain sympathy, but he also risks looking unreliable.
On 408 plus costs, 153,273. That may be amended because we're now in almost October. They have 180 days to redeem the property. We're going to have to get through the whole winter. We've got October, November, December, January, February, March. It will be the 180th day will be approximately April 1st. At any rate, let me give you my email address. It's on the notice, but it's 3bcivil@stjosephcountymi.gov.
Thank you, Your Honor. I appreciate that.
Ms. Nagpal, I don't know if we've met. Have you been here before?
I have not, Your Honor.
All right, well, you can't get here from there. You can do it by Zoom. All right, well, this seems pretty straightforward. They've got the option to redeem it within 180 days, let it foreclose in 180 days, or work something out. At least there is some communication.
Yes, Your Honor, and I believe they are just waiting to see what they can do, what they can afford. If they can't, then they'll just ride out the 180 days and then.
The big question is, should financial hardship be a shield against accountability or proof that stricter oversight is needed? Now we get to the bombshell, foreclosure. Owning property is usually a safety net, but in this case, it's turning into an anchor dragging him down. When a judge hears foreclosure, alarm bells ring. It signals not just financial instability, but also poor long-term planning. For the opposing side, this is gold. It paints him as someone unable to manage major assets, let alone installment payments. For the judge, it raises the stakes. Can this person realistically follow through on any financial arrangement ordered today? Or is he court being asked to chase smoke?
Get back the property. I think they're agreeing to that somewhat.
This is part of a reality that I've been seeing other places. There are too many dispensaries. And they've saturated the market, and so a number of the smaller ones are struggling, maybe the bigger ones too. At any rate, I'll await your order. Defendant failed to appear. See default order.
I do have that updated amount if you need that.
Yes, that would be helpful to place that on the record.
Sure, it's 153,911.46.
That's through September?
Correct. And yep, that would be through September, and then that doesn't include this, so that's just the loan balance and no other like attorney fees or anything like that.
Yes.
Yeah.
Does that include the interest as well?
Yes.
Okay, so Your Honor, that's just principal and interest. It does not include attorney fees and costs.
All right, well, the cost, the filing fee was $228.
Here's where the battle lines are drawn. The respondent wants breathing room through an installment plan. On paper, it sounds reasonable. Spread the payments, ease the burden. But the problem is trust. Installment plans only work if the court believes the payer will stick to them. His history, eviction, foreclosure, unpaid obligations, casts a shadow. The judge knows that approving a plan without guarantees could just kick the can down the road. This moment is crucial. Will the court gamble on his promise or tighten the leash with stricter conditions? Watch closely as the judge pivots. Instead of getting caught up in excuses, the judge zeroes in on accountability.
And 4175 twice, which is 41.75 plus 40.75 is $83.50 in service costs. And your contract calls for reasonable attorney fees. The Landlord-Tenant Relationship Act said the attorney fee shall be $75, as archaic as that is. Plus 228. Total costs are $386.50. Those are $228 in the filing fee, $83.50 in the service fee, $75 statutory attorney fee, for a total of $386.50.
Thank you, Your Honor.
All right. I'll see you maybe again, but I'll await your order and I'll sign it.
This is the classic tension in debt hearings: personal hardship versus the legal obligation to pay. Notice the tone. The judge isn't unsympathetic, but there's a firm undercurrent that says, life happens, but the debt doesn't disappear. This is where courtroom drama gets real. The law demands fairness to creditors, while the human story tugs at mercy for debtors. Which side do you lean toward? Hard justice or compassionate flexibility? The attorneys now sharpen their strategies. One side highlights instability, pushing the narrative that the respondent can't be trusted with leniency.
Thank you very much, Ron. I appreciate it.
So I'm here. All right, thank you.
Thank you.
Mr. and Mrs. Patel, I'll remove you and you can go on about your business.
Thank you.
All right, Mr. Thornton provides what's called a judgment form, which is very helpful for the court to understand what is alleged to have occurred. In this case, they allege that August rent balance is $1,201, September's rent is $1,395, and there's a large late fee for September. They're claiming a total of $2,696.44, plus attorney fee, court costs, and filing fee. The total is $2,933.84. Is that still accurate, Mr. Thornton?
It is, to my knowledge, Your Honor. That would include a payment of $400 that was made on September 19th. So if any payments have been made after that, I'm not aware of them.
I just made a $300 payment yesterday too.
All right, it may take a minute to clear. So your plan is to try to...
The other side leans on hardship, framing him as a man fighting through extraordinary pressures. This is where legal drama meets storytelling, because in court, perception often matters as much as fact. Every phrase is designed to paint their client as either the victim or the villain. And here's the kicker. Both arguments have truth. He is struggling, but he's also not fulfilling obligations. That duality is what keeps this case gripping. The repetition of foreclosure and eviction isn't accidental. It's strategy. By hammering these points, the opposing attorney is cementing an image of chaos and unreliability. In courtroom psychology, repetition works like branding. The more the judge hears it, the more it sticks. For the respondent, it's devastating.
Maintain this tenancy?
I mean, I would love to try to. I've been working, so every week that I get paid, I've been trying to make a payment, and then I've been in contact with Neighborhoods Inc. I've actually been waiting to hear back from her to see if I could get help getting it caught up.
All right. I've been complaining about this for a while here. They scheduled a meeting with all the funding providers, then they canceled it due to lack of interest. Well, I had lots of interest. I went to the meeting and nobody showed up. I was hopeful I could get some information about how much funding they have and how much resource they have. October 1st is their new fiscal year, so hopefully they have some money. Mr. Thornton, in light of the fact they've asked for emergency assistance, and we're going to go into October anyway, I think the law requires we continue this 2 weeks, which would be November, October 13th.
Every reminder chips away at his credibility. It's not just about today's payments, it's about proving whether he has the stability to honor any order in the future. This moment shows how facts in court aren't just evidence, they're weapons. And there it is, the collision of financial desperation and legal obligation. In this single hearing, we've witnessed a man battling eviction, foreclosure, and failed payments, all while asking the court for leniency through installments.
Are you available at 2:15 on October 13th?
I am, Your Honor.
Now, my advice is almost always the same. Stay in contact with your manager. Let her know what's going on. Let her know if they need documentation from Neighborhoods Inc. And let me tell you also, You have to pay the entire amount. Partial payment will not prevent the writ of eviction. This rent is very expensive, at least by St. Joseph County standards. And October 1st, you're gonna owe another month's rent. So you're gonna be almost $4,000 in arrears. So let's say they give you $3,000. You're still responsible for the additional $1,000 or you're subject to being evicted. So two things to keep in mind. October's rent is going to be added into this calculation when we come back, and you have to pay the entire amount to cure it. So you may decide, well, maybe I'd better move. We'll talk about that on the 13th. If you do move, I will tell you on the 13th how much rent is due, and it will be due 10 days from that day. So you're going to have until October 23rd to pay the rent or be subject to being evicted.
The judge, however, made it clear. Hardship doesn't erase responsibility. This case captures the razor's edge of courtroom justice, where empathy and accountability collide. What do you think? Should the court have shown more compassion, or was tough accountability the only fair outcome? If you found this breakdown eye-opening, smash that like button, drop your thoughts in the comments, and don't forget to subscribe for more real courtroom dissections like this one.
That's where the sheriff comes and puts your stuff out in the street. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. So you need to stay in contact with your funding, Neighborhoods Inc., Miss Wardell, and your landlord. And I will see you in 2 weeks, 2/15 on October 13th.
Okay.
Do you have any questions?
I don't think at this moment.
All right, I'll see you in 2 weeks.
All right, thank you.
All right, thank you, Mr. Thorne.
Thank you, Your Honor.
Megan is here. This case has had a couple of go-rounds, and let's call it. It's entitled William Wood and Marcia Wood versus George Wood. So George, would you have a seat over on this side?
Not, Your Honor.
What's that?
I said I would not, Your Honor.
All right, well, you can stand up. I don't care. And Marcia and William Wood are here. This file number is 251478. This is a family matter. And it's got some history to it.
Sir, I'm just moving.
You're just moving?
Yep, sir, I don't need the family problems. I'll get back title to my mom and dad and get the
All
property.
right, well, let me call the case. 251478. It's entitled, as I said, William and Marcia Wood. This is a property out in Roystown, Royce Place Road. For what it's worth, about 3 or 4 weeks ago, I drove out there. I wanted to inspect some property at a trailer park on Withers Road. And so I made a little spin through Roystown. I saw your girlfriend walking the dogs, and it was I don't remember, Friday morning, maybe, I don't remember. But anyway, I entered a judgment granting possession to William and Marcia Wood. And George wasn't here, so I entered it by default. George has filed a motion to set the default aside, waived the fee. He advised me just now that he plans to not challenge the termination and simply vacate the premises and move.
Sir.
So you don't wish to proceed with the motion to set
No, sir, I
aside
don't
default?
need it for my mom and dad. Problem is, where's Joe gonna go, sir? I don't know about that.
What's
I
that?
don't know when the girlfriend he was talking about was soon to be my ex-wife. I don't know.
Oh, I don't know. I saw a lady walking
Yeah,
across.
that's my wife, the soon to be ex-wife.
All
I
right.
got the paperwork downstairs.
She had two pit bulls.
No, they're not pit bulls.
Oh.
They're mixed, but
All right. Well, anyway, she was having a nice walk. She waved at me. She didn't know who I was from Adam's cat. All right, Mr. and Mrs. Wood, all along, you simply wanted this property back. Is that correct?
Yes, Your Honor, we're having trouble getting one of them out of there.
Who's still in there? Her?
Jody.